My name is Mike Schneider. This talk is called Legal Issues in iPhone Development. I've been giving a version of this talk really since the first 360 iDev in 2009. When I was sort of just starting as an indie developer, I had just left the law firm that I was with and felt like, bringing some of my expertise in the legal space to a bunch of developers would be a good exchange for learning a bunch of development skills. And so the talk is, I have slides that'll go through a variety of things related to people starting their own iPhone development business, either selling their own apps in the store or doing freelance work. But the hope is that this talk is somewhat small and driven by questions and answers questions from you about things that are going on in your businesses that you might want to talk about, because generally that's more interesting than just kind of the general topic. So I'll run through the slides, but I want to encourage you to raise your hand, interrupt me if anything I say prompts a question or something that has come up in your business that you want to talk about. I can't give legal advice from up here, but if we keep the fact pattern relatively general, I can talk about specifics of things that you may have come up against. To give you a little background on me, I was a tech lawyer at a big law firm based out of Silicon Valley, and I had been doing that for quite some time, doing contracts mostly around software, so helping software companies and game companies create products and sell products. And I've always been kind of a hobbyist programmer and a tinkerer, and when the iPhone SDK came out, I started making some simple apps and was lucky enough to have some apps in the store right after launch. When the bar was low enough that a self-taught hobbyist programmer could actually build things that people used and liked. And so I was lucky enough to catch that wave and was able to leave the law firm in 2009. The apps were doing well enough that it just didn't make a lot of sense to be keeping the day job. So I quit the day job and opened up Hivebrain Software, which is my own shop that I use to make apps that I sell on the App Store. Eventually settling in on a series of apps called Relax Plus, which is a meditation and relaxation app. Of all the apps that I made early on, that's the one that sort of, for whatever reason, has continued to sell for years and years. So my life now consists of spending about half my time working on the indie software business, keeping those apps running and up to date, and answering customer support questions and building new things. And then the other half of my time, I still do work for legal clients on a one-on-one with some old clients that I had from before. And my biggest client is Bungie, who makes Destiny and soon Destiny 2, which comes out next month. They're where I spend the bulk of my kind of consulting time. I also helped, I co-authored this book called The Business of iPhone App Development a while back with A-Press. And the goal of this talk is to kind of hopefully just flag in your mind issues that you might want to think about if you are either starting your own independent software company or if you're already in one, to try to spot things as they come up that you might want to just be aware of risks and pitfalls that you might fall into. And so the first one, I try to start and go through like the timeline of a business. So let's say you just started your business, or you just met your co-founder and decided you want to embark on a new an indie company making games or apps. First thing you want to think about is what kind of entity you want for yourself. So this applies to indie developers that put apps in the store, but also people that do freelance work. If you don't have an entity around yourself to do your contracts and to put products into the world, you're effectively interacting with the world and your customers one-on-one, which means if somebody gets hurt from your app, or if you end up in a contract dispute with somebody that you hired to do work for you, all that stuff flows to you directly as an individual. So you end up having personal liability, where they start taking your house and your car to pay off the debts of your business. And it's fortunately an easy problem to solve if you set up an entity around yourself, typically either an S corp or an LLC. You can create limited liability for yourself. So effectively, you're creating this entity that you own, that's out in the world interacting with people. And if the entity gets in trouble, assuming that you've checked all the right boxes and that the entity's properly formed and properly capitalized, has some money in the bank or insurance, you can use that as a really great shield to keep those claims from customers, claims from users, and any kind of attack against your business. It becomes like a really great shield. And the good news is it's not all that expensive to set up. Usually you can do it with a couple $1,000s to get everything set up and have the documents. And then there's a little bit of an ongoing expense going forward. And so one question people have is, which entity should I choose And there's really two obvious choices, either LLC or S corp for a small business. They're both flow-through entities from a tax perspective. So that means that even though you've got this other company that's protecting you from liability, the money that company makes and the money that it loses all just kind of flow through to your personal tax return. So you're not paying taxes at the corporate level and then also paying taxes personally when you take money out of the business. And so which one to choose is something you may want to talk with your accountant about. It differs kind of based on what your goals are, but typically the way I like to think of it is if you're ever thinking about like raising money from investors, if you're going to go out and either raise money from VC or try to sell your business at some point in the near term, the S corp is a better vehicle because it's kind of a known quantity. Corporations have been around for hundreds of years. There's lots of history in the case law that describes what happens if things go wrong in a corporation. And so when somebody buys stock, like an investor comes in and invests in your company, if they're getting shares in a corporation, they come in a lot more comfortable because they know that they're getting something that they know what it is. It's like they know that when you own a share of stock, you have some voting rights typically. You have a right to vote for directors. You have minority shareholder rights that keep the company from voting on certain things that would disadvantage you without having a certain level of approval from like either majority or supermajority, depending on what type of actions being taken by the company. So investors are a lot more comfortable with corporations because they know, okay, I'm going to buy this percentage of your stock. It's your common stock. I know what I've just bought. LLCs are more of a modern phenomenon. They give you all the benefits of the limited liability company, but they don't have as much of the overhead that a corporation does. You basically can design your company to fit your own needs. So like you could potentially set up a company where there's two people, it's an LLC, maybe one person owns 50%, the other person owns 50%, but one person is entitled to 70% of the profits, and maybe one person only gets 25% of the vote. I mean, you can basically, through contract, make your LLC look any way you like. So often LLCs follow a format, but investors get a little skeptical when they see they're investing in an LLC because they have to read your contract and try to understand what it is they're buying into. So it's a great, LLC is a great vehicle for like a small business that maybe it's like two people doing consulting, or even a one-person business where you're not going to take investment. You're basically just going to be a cash-generating business. The money's going to flow in, and you're going to, and so it's just a way to protect yourself from liability without as much overhead as you'd have if you had a full corporation. So let's see. Next thing to think about, you've got your company formed, and now you're going to start building something, building a product, either for yourself or for your customers, or for clients. So there's a couple ways that you're going to get that code and that design work done. You're either going to do it yourself or hire employees to do it, or you're going to hire an outside contractor to do the work, or maybe you're going to license some of that code or some of the graphics in from somewhere else. And so that finished product that you create is kind of made up of a amalgamation of things you made, things other people made, and things that you licensed in. And the important thing to make sure you do is keep track of where all this stuff comes from. The big takeaway, there's a few things in this talk that if you don't remember anything else from the talk, there's about 5 things that if you take away, those are the ones that you can just keep in your mind and get most of the value. One of them is if you're hiring a contractor or an employee, make sure you have a contract in place with them. A lot of people assume that if they hire a contractor to do work for them, to build them some code or to fix bugs, that the work product that developer provides to them is then owned by them. But actually, the default under the law, at least in the United States, is that if you hire a contractor to do work for you, you end up with a license to what they give you, and they keep the ownership, which is usually the opposite of what people are expecting when they're hiring people to write code that's going to be included in their own products that are shipped. And so without having that contract that says that, you end up in kind of a very ambiguous situation about what your rights are with respect to the thing they gave you. Clearly, they did the work and gave you the work product, so there was definitely an intention there that you were supposed to be able to use it, but it's not settled anywhere to sort of set the boundaries about, can you sell that to someone else? Can you license it to someone else? If someone comes and buys your company, is the code that developer built for you something that you can transfer to someone else, or is that license non-assignable? All that stuff is just, vague. It's not defined anywhere, so you have to kind of guess at what the intent was. So if you don't take anything else away, just know if you hire somebody to do work for you, make sure you get a contract in place that says you own the work product, unless you're expecting it to go a different way. With using third-party and open source code, the key there is just to make sure you read the licenses. Don't assume that just because something's on the internet and you can find it, that you can then bring it into your project. Nowadays, it used to be maybe 10 years ago, maybe 8 years ago, a lot of open source projects were licensed under GPL license, which is a particularly viral kind of license that would say if you bring this code that I give to you and you put it into your project, you are agreeing that you're going to make your whole project open source. So if you've got this valuable thing you've been making and you happen to pick up one piece of, one class that you bring in from an open source library and you drop it in your code, potentially you've now tainted your whole project and created a situation where you have to give away the source code for this thing you've been working on. Fortunately, the trend in the last 5 years or so, almost all the software that I use from open source seems to be BSD licensed or MIT. Those are both very permissive licenses that basically just say, hey, I'm providing you with this code. You have to know that it's as is. You have to make sure you don't claim that I'm responsible for it. And you have to, in some cases, put like a proprietary notice on it. But they're, I think the MIT license and the BSD license are both only about 3 or 4 paragraphs. So I mean, they're just really short, saying go ahead and use this, just don't hold me responsible. And so if you see something with BSD license or an MIT license, it's a great thing to use. But one thing to be aware of is that you're not getting any warranties with it. So just because that license means the person who gave you that software is not going to sue you for using it, but it doesn't necessarily mean that they had the right to give it to you. So I guess you just want to think about all the things you bring into your project and make sure you can trace them all back to where they came from and make sure that you can show someone that you have the rights. It's a bigger issue if you think you might be acquired by someone, because if a company comes in to buy your company, they're going to want to see, do they own what they built? So it's a bigger issue for that, but it's also just a good idea to help prevent, claims from coming out of the blue, asking you for money for something that you used in your software. And I'm talking kind of fast, but again, jump in if anything triggers something that you guys want to talk about. I'm happy to deviate from the slides. Another place that you might have content that goes into your app is user-generated content. And so user-generated content is fantastic. It enables you to build out your, if you make a recipe app, you can ask your users to submit recipes, and then your app becomes this great source for recipes. But what you have to be careful about is if your content's being provided by users, the big issue there is around copyright infringement, because you're taking content that someone provided to you, maybe their images, maybe their recipes, and you're putting them into your app and making them available to everyone to see. And so the risk you need to be worried about there is that something someone uploads to your system or embeds, or publishes through your app infringes someone's copyright, and then that person's going to come after you because the person who uploaded it is probably could be a kid in their parents' basement, could be somebody that just doesn't have any resources, could be somebody outside the country, and so you may be a much more attractive person for that content owner to come after if there's content being distributed through your app. And so, again, this is the big takeaway here is if you have user-generated content in your app, there are things you can do to insulate yourself from that copyright infringement. And the key is having specific DMCA safe harbor language in your terms of service or your end user license agreement. That's like step one. You have to file a document with the Copyright Office. It's basically a registration indicating to the world who people should contact if they have a copyright infringement claim against your company. A lot of people don't realize they have to do that. You just fill out the form, and I think you send it in with like $35 or something, and it checks that box. So you don't need to know all the details of what you have to do, other than if you have user-generated content in your app, know that there's some boxes you need to check if you want to get protection, and then do a search for DMCA safe harbor, and you can read about it. There's if you follow the right steps, you can fully insulate yourself from getting sued for copyright infringement if people are posting things to your app that infringe. Yeah. For reviews? Yeah, I mean, so again, you want to think the risk that you're worried about here. There's lots of risks with letting people post things to your service. If somebody was posting a review, I guess I wouldn't be as worried about copyright infringement. I'd be more worried about like defamatory content or racist or. Yeah. From a copy. From a copyright perspective, the concern would be if somebody like lifted a review from somewhere else that someone else wrote and then put it into your app, and then whoever wrote that original review might be the owner of that work and be upset that it's in your app. That strikes me in general as it seems like a lower risk proposition, not because the law makes it less risky, but because people who write reviews don't typically go out and sue people for using their reviews in other places. So it seems like from a practical standpoint, it's less likely to cause you problems, but technically it is. I'll get to that when I get to the IP section. I'll talk a little bit about what a copyright is and how you get one. But if you write something down, or if you write a review into a website, you own a copyright in what you created from the moment that that work is created. And if somebody takes it and uses it on a site without your permission, potentially you could sue. So I guess, yeah, I mean, the other thing is that the DMCA stuff, like checking these boxes, pretty easy to do. So if you have user-generated content, even if you think it's unlikely that someone's ever going to sue you over a review, still might not hurt to send in the $35 form and just set up the right process in case something happens. Yeah.
Do you know if that registration requirement only applies to incorporated entities, or does it apply to sole proprietors?
It's if you want the coverage, you have to have the form filed, and usually you indicate the domain name. A lot of times it's the company or the service is identified by the domain name. But yeah, like the first thing I would do if somebody called me and said my work's being infringed on a website with user-generated content, can I sue them? First thing I would do is I would look at their terms of service and see if they have the DMCA language. If they don't, then I'd say you're good to go. They didn't protect themselves with the DMCA language. If they've got the DMCA language, then I go to the copyright website and look to see if they've got the agency form on file. And it doesn't really matter whether you're individual or a company for that purpose. So yeah, you definitely want to file that form regardless of the entity. So it's just a good, just know if you're using user-generated content, this is out there, and if you jump through the right hoops, you can get protected. So going live, so the question I get sometimes from people that are making apps, particularly small apps, are, do I need to make an end-user license agreement and get users to click through, or should I submit? Apple has a mechanism where you check a box when you're submitting your app to them and provide your own text for an end-user license agreement. And so, as a developer, you have to decide: am I going to ask my users to sign up to something specific to my app, or am I just going to ride on what Apple's process looks like? And so, Apple has a thing kind of baked into the App Store that says, when you sign up for iTunes, it says you're agreeing to iTunes, you're agreeing to pay us for things you buy on the service. You also understand that some of these apps are provided by third parties. If you download an app from a third party, the following things apply. And so it does have a pretty good basic coverage, like limitations of liability and disclaimers of warranties on your behalf that Apple makes to the customer. So for an app like a calculator app or something that just really doesn't seem like it would cause harm to a user or be likely to give rise to a big lawsuit, if there's nothing about your app that kind of keeps you up at night thinking somebody's going to get injured, then you may be able to just kind of ride on Apple's terms of service. I've done it for a bunch of my apps. The ones that don't have any kind of really risky functionality, often I'll just use Apple's terms. But if an app uses like private information, like if you're storing people's location, if you're giving driving directions, if you have user-generated content and you need to get this DMCA language into your terms, there's a lot of good reasons why you might want to have your own terms. So I guess the thing is, think about what your business is and what your app is. If the types of risks that you're trying to protect yourself against are not common to every app on the store, maybe your app is a medical app or it's a financial app, and people are you're worried that somebody might think that the stock information that they're getting from your financial app is going to cause them to make a bad investment. If the thing that keeps you up at night about your app is not universal to everyone, you might want to have your own terms of service so you can address that specifically. Another benefit is if you think you're likely to get sued by a customer or really by anyone, having your own agreement in place with the end user gives you kind of a direct contract with that user. So it's a lot easier for you to enforce. For instance, when your contract says the user can't sue you for more than the amount they paid for the app, it's a lot easier to enforce that when you can say, you signed up to this agreement with me. We have a contract and I'm enforcing that contract that says you can't sue me for more than $10 or whatever. If you're relying on Apple's terms, you have to go into court and say, Judge, there is an agreement that exists between this customer and Apple, and that agreement says that they can't sue me for this, and I'm a beneficiary under that contract. and therefore you should stop them from suing me for more than $10. And arguably that should work because you do have third-party beneficiary rights under that contract with Apple, but it's a harder argument to make, and it's just more likely that some judge might take a weird turn and say, oh, well, you don't even have a contract with this user, their contract's with Apple and you're not Apple, so you don't get to enforce it. It's just, if you think there's any real risk there that you're about to get sued or people are going to get upset, having your own terms of service or terms of use will give you a little bit better privity with the customer and make it a little bit easier to enforce. Okay, so now you've shipped your product, it's out on the App Store, and you have to think about, okay, how do I protect myself? I'm starting to get successful. The copycats are going to start coming in. That's pretty much the fact of life on the App Store, that if you have an app that does it even remotely well, you're going to start to see apps that look just like it show up. And so this is kind of a quick overview of like intellectual property rights and the types of things you can leverage to try to protect yourself in the store. And so intellectual property is one of like three main types of property that we think of. The first one's real property. It's like houses and land. There's personal property, which are physical things that you can pick up and move around, and they're not attached to the land, and you can own those things. And what ownership of a house or ownership of a physical object usually entails is that you have the right, it's your thing, you have the right to exclude other people from using it or having it. So in the case of property, you get to keep people from trespassing. If you have a computer, you get to choose who gets to use your computer and who doesn't. And so you have the right to exclude others in various ways. Intellectual property is the same thing, except it doesn't apply to physical things. It applies to rights that are a little bit more intangible, like your right to the code that you write, or the app that you make, or the graphics that you draw. And the property right means that you own it, which means you can sell it to other people or transfer it, and you also get to decide who gets to use it. And so one of the things that I think is really cool about intellectual property, and one of the things that I think is cool about contracts and intellectual property, which are kind of like the two main things that I focus on when I'm practicing law, is I think of them as like magic, because property is like a physical object. Like in order to get a computer, you either have to have money to buy the computer from somebody, or you have to buy a bunch of parts, or you have to mine metal, and you have to obtain things. So you have to have something in order to get property. Intellectual property, it almost like materializes out of nothing. Everybody has, as long as you live in a country that has good intellectual property protection and the laws enable it, you can create something of value that you own and control with no resources whatsoever other than a big piece of paper and a pen. And so to me, it's kind of magical in that sense, because it means everybody has sort of this inherent right to be able to create things from their minds. And I love that, because it's very democratic, and it means that anybody can potentially create things of value and then own them. And so the types of IP that we typically think of when we're talking about protecting software are patents, copyrights, and trademarks. Again, they all give you the exclusive right to something, and those things are different. Copyright is protection, it's ownership of a work of authorship. So some creative work that you've created, it's an expression of an idea or a concept that you reduce to physical form in some way. So that means like a song can be a copyrighted work, but you need to record the song. If you just sing a song out loud and nobody ever makes any like impression of it, it's not written down anywhere, that doesn't become copyrightable. But if you create something new and creative and you fix it in a tangible medium, which means either write it down, store it to a hard disk, save it as an audio recording, you have a copyright in that work you created, and it exists automatically from the moment you create that thing. And you can file a copyright registration with the US government to get a little bit better rights. It makes it easier to enforce your copyright, but technically speaking, you have that right inherently in just creating the work. So it's copyright is great for protecting software because it's cheap, effectively possibly free, and it covers things like your code that you write, to the extent that it's not purely functional. Anything you put into your app that is creative can be owned by you, and if somebody steals your code or reverse engineers your app and pulls all your content, often when people rip off an app, they'll take all the names of things, they'll take the directions. I have my apps that I do now are mostly meditation and relaxation based. I had a patent or a troll or a copycat in Russia basically take my app, take all the content out of my app, all the audio that we sell on a track-by-track basis, repackage it up, and sell it on the App Store under his own name. It took a long time to get Apple to do anything about it. And then I've had other companies where they don't take the audio, but they've made a whole app that basically looks exactly like mine, taking all my graphics and even my icon, and then have to worry about getting them to stop. And so the copyright piece of it covers things like the icon and the graphics and the user directions and the names of the tracks, things like that. And so that's a good start for protecting your IP. Patent rights are less practical for app developers. Patents are super strong. They protect, so when I said copyright protects like a expression of an idea, like it protects the poem that you wrote or the novel that you wrote. Patents protect ideas. So if you have an invention or an idea for how to solve a problem in a novel way that adds value, you can actually get protection for that idea itself, no matter how it's expressed. And so, it's extremely powerful. But it tends to be fairly expensive. It costs around $10,000 to get a patent. It takes several years, usually between 2 and 3 years, unless you pay for some kind of expedited review. And so based on like the App Store model, it's just not a great solution for most people. And software patents are starting to become a little less favored in the courts. So the rights you get at the end of the patent process for your software may not be as strong as they would have been a few years ago anyway. Yeah.
So I remember 5 years ago or so, there was a lot of furor about patent trolls.
Yeah.
All these things up. So you're saying that has become more relaxed now, and you don't have these patent troll companies that are basically suing people over concepts.
Yeah. The patent trolls are still there. I wish they were gone. What's happening is the court system is starting to react a bit to the trolls. So they're seeing these lawsuits that are in some cases baseless or around patents that are really not that novel or unique. Patents are really easy to get. Like, they take a lot of time, but usually if you pay the money and you go through the process with the patent office, they'll issue you a patent on something. That bar to get the patent is like, just because you have a patent doesn't necessarily mean your patent is good. It just means you have a patent that you can then assert against other people, and they can then try to argue why it's not good. And the court gets to decide if, because the patent office only has so much resources to try to turn over every stone to try to figure out if this thing you created is really, truly new. So these patent trolls get patents on really broad stuff. They enforce it against people and try to extract some cash, like almost as an extortion. They do it in an entity that is what they call a non-practicing entity, which is like a nice way of saying patent troll. It means that the patents exist in a company that does nothing else but hold those patents, so that when they come to sue you, you can't really sue them back for anything because they don't do business. They're just the patents in a company. So like, you can't sue them back and say, oh, well, your thing is infringing my thing. And they'll say, well, we don't have a thing. We just have these patents. But the courts are starting to catch on to the fact that a lot of this stuff is BS. And software in particular, they're trying to, it's always been a question about whether software was patentable in the first place. There's been a lot of case law around it. For a while there, the answer was yes, software is totally patentable as long as it meets all the criteria. But lately, there's been so many patents where people take a thing that exists in the real world and they say, I think what a good example is like a calculator. Like, calculator exists, and they're like, well, I want to get a patent on a calculator that's on a computer. Or I'm trying to think what a better example is, like a painting. It's like something that people have been doing for centuries, but now they're going to, like, a way to do it on an iPad, and they're like, oh, I'm going to get a patent for doing this thing that everybody's been doing this way for years and years, and I'm going to get a patent on doing it on the iPad. And the courts are starting to figure out that that's not really invention.
A real example of that was I'm an escrow agent.
Oh, yeah?
But I'm an escrow agent on a computer.
Right. Yeah, they're like, you can't be an escrow agent on a computer. Business process.
But they said, if it's on a computer, I'm performing escrow over the internet.
Right.
Like, it's just escrow.
It's the same thing. It's the same thing everybody's been doing, but you can see, like, the courts are slow to catch up, the law is slow to catch up, and these patent trolls live in that gray area to just extract value out of the fact that things haven't really caught up yet. And as long as it's not perfectly clear, there's going to be people that are in court trying to make money on the fact that they can sue somebody over this thing. So East Texas is like the place where all the patent trolls sue. They've got really favorable judges there. They know it's a great place to sue. I feel like that it's like they've got a cottage industry of
One judge.
yeah. It's
One judge.
it's scary. There's a reason why all the patent trolls have like empty offices in Texas. They're like located there. There's no people there, but they want their like to be domiciled in Texas so they can sue in that court. And they're starting to catch on to that too. Like I think Congress and Senate, if they could ever get anything done now, that was sort of before things kind of went crazy, was on the list. Patent reform seemed to be happening. So I don't know if it's still happening or not. But yeah, it seems like the patent situation is getting better. As a person who could potentially be sued by other people, it's getting better. As a person who wants to use patent to protect their own rights, it's never been that great for iPhone developers, but it's probably even less worthwhile now because of the cost and the time and all that. Yep.
So as you said, getting a patent is very costly and time-consuming. Does it make any sense to make initial applications to get to a
Patent pending. Yeah.
Does it actually protect you a little bit?
So, yeah, that's a great question. So patent pending is like you can file what's called a provisional patent with the patent office. A provisional patent is basically you are writing down the gist of your invention, with enough detail to show that you invented it and that you've got the details there. You file that with the Patent and Trademark Office. You pay a smaller fee for a provisional patent application, and that patent application that you send in basically just gets stuck in a file. So nobody reviews it. It's relatively inexpensive to do. Potentially you could write it yourself if you weren't too worried about. Sometimes patent lawyers, when you tell them I'm going to write the provisional patent myself, they get a little nervous because they're afraid you're going to do something that's going to make their job harder when they have to file the real patent. But basically what the provisional patent is doing is it's like a placeholder. It's saying, I am planning to file a patent. I want everybody to know that as of this date, I have invented this thing, and I'm working on a patent that I'll submit. And you have up to a year from the time you file that provisional patent to file the real patent. And so some people like to file a provisional patent because it allows them, from the moment they file the provisional patent, even though it just gets stuck into the file and nobody looks at it, you can still call your thing patent pending, which doesn't actually give you any real rights. You can't sue somebody for doing anything. If they do the exact same thing you did and you're patent pending, you still can't sue them unless you actually get a patent and it issues. So, if you see a product that you want to emulate and it says patent pending, it doesn't necessarily mean you can't do it. But it's a warning because you're saying, oh, well, these guys are working on something. Do I really want to invest my time and effort into building something that a year from now they might have a patent on and I'll have to stop doing? Yeah. No, it really doesn't have any real legal effect other than the fact that you get to put that stamp on your product, and it's kind of like a shot in the air to maybe scare away people that might be thinking about copying you. Because they just don't know, what your plans are, and if you have a great patent, they won't get to see your patent until it issues. So, for all they know, they just know something might be out there, and it's kind of like it introduces a bunch of risk into their business, and maybe keeps them from investing more money into the thing. No, and there's really no way to search for patents that are in process. They're all private up to a certain point. So for I think it's 18 months after you file a patent, it's not public. Usually they have this thing called submarine patents, which is where somebody files a patent, it sits dormant, and you don't know it's pending. They watch, so you can imagine something that's moving really fast, like cryptocurrency or Bitcoin. Somebody files a patent on that stuff and just lets it sit while they let everybody else spend 18 months building up these big businesses, and then their patent pops out of the blue and it reads on exactly what everybody's doing. And it's, so it's kind of scary. And that's why the patent troll issue is such a big deal, because you just can't, copyright's pretty easy to know if you're going to get sued for copyright infringement, because if you don't steal pictures from someone and you don't take their code, they really don't have much of an argument that you've stolen their copyrighted work because you didn't copy their stuff. But with patents, there could be a patent out there that hasn't issued, or a patent that you don't know about that could just pop up out of the blue. All of a sudden, you've got a problem that you really had no way of knowing was coming. It's pretty scary. I'll speed up a little bit because I know we've got about 10 minutes. Trademark. Trademark is the one type of intellectual property that I think most iOS developers should be thinking about as their primary way to protect their thing. It's inexpensive. It usually costs the filing fee is a few $100s. You could potentially do it yourself if you want to read a lot on the web. They have the Patent and Trademark Office has a website where you can file a trademark yourself. It's almost like a Quicken style thing where it will talk you through the points. Going through that process and spending the $370 or $325, whatever it costs, definitely better than doing nothing. If you hire a lawyer to do it, I don't do that sort of thing, but I think it generally costs around $2,000 to get a basic trademark filed. But then those trademark rights can potentially run forever. They don't expire like copyrights and patents do, and they're really pretty solid, because typically when somebody rips off your app, they're either going to make their app look like yours or have a name like yours. It's going to be hard to stop them from taking your idea, but you can very easily stop them from taking your, I don't know, brand identity. So Flappy Bird is a great example. I mean, obviously, there's a million clones of that on the store, and I don't know that they're using that trademark very, very effectively to stop those people. But you can't really stop someone else from making a game that plays like Flappy Bird. But Flappy Bird's got a pretty distinctive look to it. It's got this word Flappy in it. If people are calling their game Flappy Cars, it's possible that they could have gotten some trademark protection over the word Flappy and really owned that space better than they have. And it's so anyway, as an app developer, I think trademark is the way you want to be thinking about protecting your work, because it's the most effective. It's best bang for your buck. It lasts potentially forever. It's great. So I guess the takeaway there is, think about getting a trademark. When you're picking a name for your app, some names and logos are more protectable than others as trademarks. And there's a range from things that are generic, like Bleach, to things that are completely fanciful, like Accenture. And then along the way, you can see sort of the spectrum of things that are distinct. Like, so if you have a product that describes what you sell, like if you open a grocery store and it's called Grocery Store, or Bob's Grocery Store, you're going to have a hard time stopping other people from using that name, because it's just describing the thing that people are buying from you. And the government doesn't want to take those words out of people's vocabularies, where they can no longer call a grocery store because somebody claims that they own that. So in order to get protection for a descriptive mark like Sports Illustrated, you have to go really far to show that the world knows that that's you and not the words, that you've created a market for that brand, that people have identified it. They've created what's called secondary meaning in that name, that people don't just think Sports Illustrated means Sports Illustrations, but it also means this magazine. So Sports Illustrated has a great mark because they cross that threshold, but it's a hard threshold to cross without being in the market a long time and spending a lot of money on marketing. Names like Groupon, it's kind of suggests that it has something to do with groups and something to do with coupons. That's better than calling your site Group Coupons. Can't really protect group coupons, but Groupons is kind of unique, and you can at least make the argument that if somebody else wanted to make a coupon site for groups, they wouldn't have to use the word Groupon. So that's, I guess my point would be, if you're thinking about names for your apps and things, think about like going from suggestive up to fanciful, and try not to pick things that are too descriptive of the thing you're doing, or you'll find that it's just not very protectable. There may be upsides to calling your app what it does, because at least people will know what it does right away, but your trade-off there is that you may not be able to prevent other people from using the same name. Okay, so some quick myths. I think I talked about some of this stuff, but these are, again, kind of big takeaways. Myth number one, I paid for it, so I own it. Again, can't reiterate it enough. Like, get contracts in place with people that do work for you. If you pay for something, it doesn't necessarily mean you own it and get to do whatever you want with it. I can use pictures on the internet as long as I give credit. That's also not true. Every image on the internet is owned by somebody. If you happen to take it from the wrong people, like Getty Images or Corbis, you will absolutely get letters, and they'll try to get you to pay after you've used it. There are copyright trolls that exist, kind of like the patent trolls, that they'll buy up a library of stock photography images, the ownership of it. They'll buy an artist's or a photographer's portfolio. They'll get a copyright application that covers everything, and then they will put the images places where they know people can find it, and then they scan the internet looking for people that use those images, and then start sending letters saying you're using our image. If you have a copyright registration and someone takes your copyrighted work, you have the right to statutory damages up to $100,000 per copy. So when you send somebody a letter that says, you're using my copyrighted work, here's the copyright registration, it's on your website, and you've been using it for the last year, and we, by the way, if we go to court, we can collect up to $100,000 for this. Makes it pretty, it can be a pretty scary letter. Same thing with source code. If you find it on the internet, doesn't necessarily mean you can use it. Just make sure you can tell what the license is. There's some limit to that. If you're picking like a single line of code from something that, like an example someone put online, and it happens to be like the only way to sort an array, I wouldn't worry as much about that. But if you're taking big chunks of code from a project, you need to know whether you have the rights. And then just generally, people tend to they overestimate how much is permitted by this concept of fair use. That, oh, the thing I'm using, I'm only using a little bit of this thing, or I'm putting this stuff like into my app, and I'm using it in such a way that I think it's fair use. The problem with fair use is that it's a defense against infringement, but it doesn't keep you out of court. So if the thing you're doing is going to piss off the person who owns the copyright or the trademark, the fact that you think it's fair use, unless you're really clearly on the bright line of what is fair, most things in fair use are in the gray area, which means that big company can still sue you, and now you're just stuck in a lawsuit defending why you think the thing you did is okay. And if the company's big enough, it might not matter whether you win or lose, you still lose, because lawsuits are incredibly expensive. So people generally feel a little bit more free to use things that aren't theirs with this idea that it's fair use. And I guess I would suggest, if you're thinking that you're using something that's fair use, just take a closer look at it. Make sure you give it more thought, because people tend to overestimate how powerful fair use is. And this is my information. I have a podcast called The Law of Startups. We've been doing it for about 2 years. We're up to around 120 episodes. It started out as a law-based podcast, but mostly we just talk to entrepreneurs about stuff they're working on. It tends to be a little bit Seattle-focused, because that's where I am, and my partner on the podcast is also there. So, but yeah, check it out. I'm on Twitter at HiveBrain, and I'll be around for another couple hours. Feel free to ask questions, and I'll hang out here too if you have anything specific you want to talk about. And thanks for listening. Hope I didn't go too fast.